Thank you, Marlon and Suzanne and Bonnie. And thank you to all the folks that are out there listening and wanting to discuss this issue with us. This is one of my very favorite topics. I'll introduce myself, then toss it over to my dear friend and colleague, Bonnie Claremont. I'm Kelly Stoner with the Tribal Law and Policy Institute. I have worked there, I don't know, I'm going to say 14 years. I don't know. It's been a long time. I'm a lawyer. I think if I have a specialty, it's this. This is, again, so important. And I hope we have really, really good information for you all today and want you to be sure that you're chatting. We have people monitoring that. I was a judge for 8 years with the Seminole Nation of Oklahoma. Before that, a law professor for 22 years, teaching on topics just like this. And I currently am a justice for the three affiliated tribes Supreme Court. And with that, Bonnie, I'll turn it over to you. I think you're muted, Bonnie, maybe. There
Sorry
you go.
about that.
That's okay.
Thank you, Kelly. My name is Bonnie Claremont, and I also work for the Tribal Law and Policy Institute as the Victim Advocacy Program Specialist. I've been with TLPI for about 21 years or so, and I am based in St. Paul, Minnesota, where we opened an office when I started with TLPI. And our focus is helping tribes address, develop programming, expanding their tribal courts to address issues related to domestic violence, sexual assault, stalking, sex trafficking, and so forth. I am a citizen of the Ho-Chunk Nation and originally from Wisconsin, and I've been in St. Paul for most of my life. Grew up here, but still connected, very connected to tribal communities around the state and also across the country. And part of that is doing the work of training and technical assistance to tribes. So I've had the privilege and honor to visit many tribes, and I think I probably have met many of you in my travels. So welcome to the webinar. Hope you find it helpful to you.
Thank you, Bonnie. And I should mention I'm from Oklahoma. I don't know if you can hear it, but it's there, the accent. But I'm coming to you from my new home for over a year and a half, northern Utah. So, and I also wanted to say this. As we were putting all these PowerPoints together, you will see that there is an advocate segment, I should say, and a legal, more lawyerly segment. And that's because, and Bonnie, you can correct me if I'm wrong. I think in especially domestic violence cases and sexual assault cases, it is critical for lawyers to work alongside the advocates. And we do have a presentation coming up on confidentiality and privilege. We'll talk about that towards the end of the presentation. But I've been doing this work, oh, I don't know, I want to say 35 years maybe. And I can't tell you how much I learned from working with my first tribal victim advocate, things I had never thought about victim safety, about victim struggles. And in my mind's eye, I think that is probably best practice for these kinds of cases. Do you agree with that, Bonnie?
Absolutely.
Okay, great. And you're
Before coming to,
Go ahead.
hello, before coming to the Tribal Law and Policy Institute, I worked for many years, probably well over 20, 25 years. And a lot of the victims that I worked with were in desperate need of victim legal services. So, being an advocate, oftentimes, the victims we work with they have inherent trust in us as their advocates. And it's easy to step over those boundaries of, giving legal advice or giving information about legal issues or the law or trying to interpret the law. And I used to stay clear of that. So this project I'm very excited about. So being able to, present this particular topic fits within that in terms of the importance of protection orders and how that could be a real lifesaver for many victims.
Thank you. So let's dive right in. We could get to the next slide. There's the disclaimer, thinking I don't need to read it. The objectives of the presentation, we're going to discuss the importance of completing an application for a protection order. That includes, if you're in tribal court, tribal legal elements. And we really kind of broke this down into two chunks today. We're going to talk about how important filling out that application or petition for a protection order can be to the victim, and then we're going to talk about some additional language that needs to be in that protection order if you want to activate the federal full faith and credit requirements. So we're going to do some talking. I know not all of you are lawyers out there, but if you're advocates and you're filling out this paperwork, there's no reason why you can't absorb this. There's nothing magical to it. And I want you to pay really close attention to the elements and then how to activate the full faith and credit. And then we'll end with drafting remedies. So the next slide, please. Okay, we start with a knowledge check. Why is it important to draft an application for a protection order? Why is that important to your client? You can chat, and if you hadn't had enough coffee, you don't want to chat, I'm going to tell you in a minute, but we'll give you the opportunity to warm your hands up. Why do you think drafting that petition or application for a protection order is so important to your client? Oh, yes, the advocates are very important. As a matter of fact, the advocates are going to get the story before the lawyer in most instances. Yes. Okay, there's one. Drafting allows you to proof it first and then add on. Make sure you have everything in there you need. Very good. So let's, in the interest of time, let's just move on to the next slide because I told you I'm going to give you the answer. It's too important. We got to get it down. I'm going to talk to you as a former judge right now. A judge is interested in the elements, that you've met the elements in the statute for the judge to even issue the protection order. And I know a lot of times the client is going to come in, going to tell a story. I usually always like to have, when I was a practitioner, usually always like to have them write it down. It gives them something to do. And they can go back and look at it, see if they've left anything out. But that is me looking through the lawyer's lens. And Bonnie, I'm going to say an advocate is maybe not so mindful of the elements. They're wanting to get the story and what the client hopes to achieve. Is that right?
Absolutely. Absolutely.
Okay. So let me just say that again. Most clients are going to tell Bonnie the whole story. They may not tell me the whole story the first time because Bonnie the advocate has built that trust with the client. So let's go on. We're really going to focus on the elements here. For those who are not lawyers, advocates, same for you. If you're helping these victims fill out this application or petition, whatever it's called in your jurisdiction, you have to be mindful of the elements. Next slide. Okay, here's your checklist. Have you reviewed the tribal statutes? Have you pulled out the legal elements? We're going to practice on that. I chose a tribe and a state, so you can kind of see how they're different. We're going to talk about Quapaw from Oklahoma and the state of Oklahoma. Just they were easy for me to find, no other reason. We're going to practice identifying legal elements. And then we're going to talk about discussing those elements with the victim. So let's just set the scenario here. The client's already come in and met with Bonnie. She's got the whole story. She's come in with me. I found in my history of practice that oftentimes the victim doesn't want to tell me the more intimate details. Anything she thinks might be shocking to me, she may not want to tell me on my first visit. But those of you who are advocates out there, you already have that information. We want you to review the hearing dates. There'll be separate hearing dates, and we're talking right now about tribal law. For an ex parte order, that's your emergency order where you take her back to the judge's office. The judge listens and then decides whether it's an emergency order. And there will be additional dates for the permanent protection order hearing. So you've got to know those. I tend to like to get a file, just one file for protection orders. Unless you're in a different jurisdiction, then you'll need a file for that one. And I keep all these things tucked away so I don't have to look them up every time. You want to note any jurisdictional requirements. You're going to see that set out in the QAPA example that we have for you. So if you're in tribal court, you have to demonstrate the court has the power to hear the case. So you're going to look up the jurisdictional pieces. And then you need to know, and there's usually a statute that tells you what is the length of time your client can get this protection order for. And you need to tell her. And she may want a shorter time. She may want a longer time, but we're really going to have to focus in on what the statute says. So that's your little checklist before we even get started. And again, I can't tell you enough. I've seen advocates bring their folders into court. So if the judge doesn't know the answer, they can pull the statute and say, here it is, judge, here it is. All right, next slide. All right, let's dive right in. Remember, I'm very interested as the judge in what the elements are to get a protection order. And I just pulled this offline. It may not be the most current version, but this is the definition of domestic violence. So if I have a client who is experiencing domestic violence, I'm looking at this statute. I want to give you just a couple of seconds to skim over it. We're going to go over it in depth. It's telling you what acts I, as the judge, can recognize as domestic violence, how old or older, 13 years or older, and or they are a minor family of a house or a household member. So that's all very important information. So let's go to the next slide. And I think we were going to drop the QAPA petition for a protection order in the chat so you can look at it, because QAPA is one of the tribes that actually puts the elements in their petition for a protection order, which I find extremely useful, especially if you forgot your folder I told you to have, then you'll have it right there with you. Let's go to the next slide. Okay, here it is again. Can you take just a couple of seconds to write down any elements you see there that I, as a judge, need to hear about in order to grant this protection order? There are several of them in there. You only have to type in one. Physical harm, you got it, Lacey. That's one of them. Fear of imminent harm, you got it. Bodily injury, yes. Okay, you guys have it. Great, great job. So this, I know the client wants to tell her story. Yes, and the minor age, they have to be over 13. So here's the scoop on this. These things you just typed in there is what I have to hear evidence on. It could be any one of them. Some clients will come to you with all of them. So you want to be sure you hit them all. But you're going to take the client's story that Bonnie's got, and we're going to weave the testimony in by element. How did he physically harm her? What did he do to her? Bodily injury. Does she have police reports? Did she have to go to the ER? What did she have pictures? A lot of advocates will take pictures of these bodily injuries. Does that make sense to everybody? We, as a lawyer or advocate, lay advocate, we have to pluck out from that story and match it up to each one of these elements, or at least one of these elements. Does that make sense? And it may not be the same. It's not going to come out the same way that it came out for Bonnie. I personally, as the lawyer, am going to pull out that part, and I'm going to go through each one of these elements and attach her story that's relevant to that element. And then at the end, we can tell the rest of the story. But this is what the judge is looking for. Anybody have any questions about that? It seems like such a simple thing, but I've been doing this a very long time. I always called it mapping, and I would have the client write the story, or get the advocate would share the story if the client gave permission. And then I would begin to just go in and pluck out. I would write physical harm, and I would write all of her testimony that has to do with physical harm, bodily injury. And I do it in the same order that's in the statute, because that's the way the judge is thinking. We want to hit them all if she has evidence. If she doesn't have evidence of an element, we'll leave it out, because any one of these gets it for your client. Does that make sense? I can't see anybody, but I'm hoping you're shaking your head yes. Okay, let's go down one more slide. And there we see the elements again. And if you look at that QAPA petition, if you have it, you can download it there. You will see that it starts with the petitioner's relationship to the defendant. This is the application for the protection order. There's also a statement of jurisdiction. We're going to get to that in just a minute. You're going to check that off. Then we're going to talk about the actions of the defendant. And it starts with physical harm. Then you put the story there that goes there. It goes imminent physical harm. You'll put the part of the story that matches up with that. And it also includes harassment and stalking in this protection order. I only pulled out the domestic violence piece of the statute. And then it'll say what happened. What's the description of the incident? Then she could put the rest of her story there. And then it asks, do you want an ex parte order or a permanent order? And then it goes down through the types of relief that are found in the statute. So I find this petition for protection order very tightly written. It goes through all the elements, but that doesn't stop me from going back just to make sure all the elements are in there. And so again, these are the same elements that you identified for me earlier. This is what the judge needs to see first. Now, let me tell you what happened and why I say that. A couple of months ago, I do some mentoring work for some attorneys in Oklahoma, and I think it was an advocate. It could have been the attorney, though. I hope not. But anyway, they filled out the protection order, and all they told was the story. And guess what? The story didn't meet any of the elements at all. So the defense attorney files what's known as a summary judgment motion. Let me tell you what that means. It means, judge, look at this application. Even if everything in here is true, they don't meet one element that they have to meet in order to get a protection order. Now, we won. There was no summary judgment issued, but it scared me. And I thought, wow, we really have to get the word out about how important drafting that petition for protection order is. A victim doesn't need to get to court and have a judge say, you didn't meet any of the elements, sorry, go write it down and come back. It's deflating, it's traumatic, it's demoralizing. She's thinking the system is against her. So we need to do our job better. And I'm not saying you're not. Maybe some of you are doing wonderful jobs, especially if you get to work for a jurisdiction where you, like QAPA, where all you're going to do is check it off and you know you've met the elements. So that is super important. And I think that's my message to you today. The judge's lens is going to be honed in to these elements. Sometimes you'll get a story and the judge will be trying to pick the elements out of the story, but how much easier is it for your client if you address each of the elements, part of the story, next element, part of the story, and she tells the rest of her story towards the end. So, okay.
Hey, Kelly,
Yes.
we had a question. The
Okay.
question is, are these elements very similar to many tribal codes?
I'm going to say maybe my true lawyer answer. You're going to have to go back. Every tribal code is different. Some tribes have borrowed from the state court, so the state and the tribe's elements will be the same. You're going to see Quapa's done some different things here. And Oklahoma doesn't have all these elements. In Oklahoma, we'll go over that in just a minute. There's just a few elements. So I wish I could say yes, but no. It's probably maybe. You've got to check. Remember when I said make your folder? You need a folder of the tribal laws that deal with protection orders. That's the best way to do it. Check it yourself. Even if you get a beautiful petition for protection order that looks like it has all the elements, go back to your statute and check them off. That's super important to your client. Okay, any other questions, or let's move to the next slide.
I think we're good.
Okay, let's stay on Quapaw for just a minute because this is Quapaw flexing their sovereign muscle. We'll get down here a little bit later, and you're going to see that the federal law says tribes have civil jurisdiction to issue and enforce protection orders against any person. Okay, that's very broad. Quapaw says in our court, this is the way we do it. Okay, and so if you look down through there, it says we can issue emergency, ex partes, and final orders. Petitioner, if the petitioner is a resident or employed within the Indian country of the Quapaw Nation, or the spouse or intimate partner, or otherwise engaged in a dating relationship with the member of the Quapaw Nation or an Indian who resides within the Indian country. So Quapaw says this is our jurisdictional statement, folks. The judge says if you can't check one of these, we don't have the power to issue the protection order. We've got to have that in there. So you also want to make sure any jurisdictional requirements make their way into your application. And Quapaw has they have a whole section on statement of jurisdiction, and it lists the statute, and you check which box your client meets. Now we've got a strong application for a protection order. Now we know even if there is a summary judgment filed against us, it's not going to win. Does that make sense? Now we're really taking the law, we're weaving the client's story into it for the judge, we're making it easier. This is the judge's first impression. And we want to say we are organized, we've read the statute, we've given you the elements and the pieces of the story that go with the elements, and you have jurisdiction to issue this, judge, according to tribal law. Okay, next. Any questions? Just ask me anything. Okay. And this is, again, just kind of going over the jurisdictional piece. I think it's really good if you have that copy of the Quapaw petition. You can't really copy it and use it unless your statute matches Quapaw's, because it won't be the same. Okay, let's go to the next slide. All right, again, going over the jurisdictional pieces, and let me just really stress for the non-lawyers out there why this is critical. If the judge doesn't have the power to issue the protection order, your client's gonna lose. So we're screening this too before we take them into tribal court. We're looking at this and saying, okay, you have this one or this one, so we're good to go. And judges, again, jurisdictions just as important as the elements. Next slide. Bonnie, do you want to have anything you want to say here?
No.
Okay, Marlon, let's go to the next slide. Okay, just wrapping up here. You're gonna, what we've done, identified the tribal legal elements in the statute. That was bodily harm, physical harm, bodily injury. We've referred to the tribal petition for protection order. We made sure all those things were in there. That's running our check. Then we're going to pluck out pieces of the story and match them up to the elements. And it's okay if your part of the story meets two elements. I would put it in there twice. Then we're going to look at the hearing dates. You'll probably, if it's an emergency order, you'll probably get one that day. If it's not, if he's incarcerated or something, she doesn't feel she needs an emergency order, we're going to use the timelines for the permanent order. We're going to figure out how long she can get an order. I've seen it as short as 2 years and as long as a lifetime order. It's really up. It's going to depend on tribal law. And then the remedies, which we haven't talked about yet, but I'll just plant this seed with you. Look at the statute and see what remedies I, as the judge, can order. And hopefully within that statute, there's a list of remedies, but then there's one that says something like, and any other remedy the judge feels will bring about the end of the domestic violence. And that's my loophole. That's your loophole to get in and request other remedies. But let me give you this tip. If you're going to ask for a remedy, you must have put some evidence in, can be her testimony. You don't have to put this in the petition. But if you already know it, I would put it in there. Let's say she needs the car. It's the only car. She has to take the kids to school. She needs the car. You look down the remedies, you don't find anything about awarding personal property, things like that. I'm going to put that in under other. And then while I'm in there, I'm going to have her talk about that, put on her testimony about that. Hoping this is making sense because I can't see y'all. If you have questions, please put them in and you'll have the PowerPoint. So you can see I'm big about folders with all the pieces of information you're going to need that we talked about in the beginning. And I'm also about checklist. Did I do each one of these things? I think lawyers and advocates alike can use this. Next slide. Okay. I wanted to give you an example of a state statute. It's different than Quapaws, and that's okay because they're a sovereign nation. They know what their tribal communities need. And when we look at this one with my judge lens on, it says domestic violence means any act of physical harm or threat of imminent physical harm. Has to be committed by an adult, someone over the age of 13, or a minor child who is currently or was previously in an intimate partner or family household member. So members of the household. Okay. What jumps out at you here? How is this different from Quapaw? Give you a second because you're probably shuffling papers. Again, I'm only looking for those elements. The judge wants those up front. Okay, emancipated minor, 13 years old, good. But there's only 2 elements in here. No SA, very good. Thank you, Patrick. No SA, doesn't include, yes, intimate partner. But we only have 2 elements here. So if you were practicing in Oklahoma or getting protection orders for clients in Oklahoma, you would have to either demonstrate an act of physical harm or the threat of imminent physical harm. And that's the only way you get in to get a PO in Oklahoma. Now, they may have other statutes that talk about sexual assault and harassment, but their domestic violence statute only has two elements. So think for a moment. I know some of you all are from Oklahoma, as I was trying to look at the list as you guys were telling us where you were from. These tribal advocates are going into tribal courts and then skipping over and going into state courts sometimes. So they have to have different forms for the different courts because they have different elements. So this means that I would take that story we talked about earlier, and I'm looking for testimony in her story about physical harm, or she felt that she was being threatened with imminent physical harm. I'm going to kill you. You're going to pay for this. Anything like that, I would argue, if she believed it was imminent physical harm. So very different approach than what we saw with Quapaw. Next slide. And you have the Oklahoma protection order form there as well. It too is a checklist. We can skip on down, Marlene. It too has a checklist. They go through intimate partner first, and then they go through family or household member. And then they are required to discern whether they're a victim of DV, harassment, adult victim of another crime, stalking, rape, child abuse. So this is broader than domestic violence, this petition, because domestic violence only had those two legal elements in it. Then they go through their statement of jurisdiction, and it looks like this. Petitioner is a resident of the county where the petition's filed. The defendant is a resident of the county where this petition is filed, or the DV occurred in the community where the petition is filed. So they're kind of walking you through, and then they get to the actions of the defendant, which match up with this perfectly. Cause or attempted to cause physical harm or threatened imminent physical harm. So the next time you see one of these petitions for protection order that has the elements in it, you can go back and say, yep, it's all there. It's all there.
Hey, Kelly.
Yes.
We had a question about whether sexual assault could fit into physical harm.
I haven't looked at the definition of physical harm in Oklahoma, but we would, yes, I think in almost every instance it would. It doesn't say bodily injury, it says physical harm. Was there ripping of clothing? Was there anything like that? A lawyer is going to tie into physical harm. And if you have sexual assault with injury, I think, yeah, for sure you have it.
So or make the argument.
And I also think that if you, if even if the sexual assault isn't completed, in other words, there's an attempt made, we still may have physical harm. We still may have imminent fear of physical harm. So we're thinking about, while we're doing this, what pieces of her story can I plug in here? Because I'm going to plug in a little. I may not plug it all in, but I'm going to plug in enough that I think meets the element. Think I got all those questions right? Is that correct, Suzanne?
Yes.
Okay. Okay, next slide. All right, here's our checklist. Did we identify the state legal elements? We did. Did we refer to the state petition for protection or make sure all the elements are in there? We did. Did we connect the client story segments to the elements? I hope you do that. Then we're going to look at the hearing dates again. We're going to look at how long can she get a PO. And I don't want you to forget about asking the client what she wants, because she may have something in her mind. She only wants 6 months because she's moving or something. So you want to be sure and do what your client is asking you to do. And then we're going to be talking about those remedies a little bit later. And I already gave you my little tip. Don't ask for remedy unless you put it in the application why you need it. What's she going to say why she needs it? Bonnie, do you want to add anything so far?
Actually, yes, I wanted to just as a advocate who, if you work with a victim, you have some history. And I've seen so many times where victims minimize the past abuse. They think it isn't really abuse unless there's physical contact and bruises. And yet, often, I'll keep in mind when they say, well, he was threatening before all that happened, he started threatening me and scaring the kids. And that I would remind her in before going to do the application, of those times, not to put words in her mouth, but to remind her that those count and that they should be included in the application, because otherwise it's kind of like, well, the threats don't count. It wasn't that bad. Oftentimes victims, and yet the myths are out there that victims make up all this stuff, right? And yet, on the other hand, there's victims who often minimize unless there's actual physical contact and bruises. So it's really important if advocates have that history, just to remind the victim that those count, the threats, because that's when the escalation happens to where most often it ends up in actual physical harm where she's beaten and so forth. So
And that's great, Bonnie, because that is the definition of fear of imminent physical harm to her or a household member there. And I will tell you, when I was on the boots on the ground representing victims, it was so interesting to me because my advocate had the full story. And I would work with the advocate. So I would get most of the story with the client's permission, of course. If the client didn't want the advocate to disclose something to me, then she did not. But I oftentimes heard about sexual assault in the relationship towards the end of my representation. And maybe you can explain that, Bonnie. I was building the trust relationship, but she was embarrassed and she didn't want anybody in that courtroom hearing about what he had done to her. And
yeah,
we always go with our client and their wishes because they are the experts at staying safe and they know what they want to do. And lawyers, please don't forget that. Your client is driving the ship here. It's not, I know in law school, you come out and you think, oh, I have to win everything or people aren't going to think I'm any good. You win when you get your client what they want, how they want it. And why would a client, do you think, Bonnie, not talk to their lawyer about very intimate details and not want it disclosed to the court? They just want them to know they trust me and they can tell me, I
yeah.
think.
It's fear of, retribution also from the perpetrator, the abuser, the batter, whatever you want to call them, or the family of that person. But also there's a lot of victims who don't even see rape or forced, sex as rape, as a sexual assault. They just think that's part of, your relationship to give sex on demand. That's part of the relationship when, they may have been feeling uncomfortable. They're afraid to say no for various reasons. So in addition to them feeling just embarrassed and ashamed of what's happened, they may not even recognize what happened as sexual assault.
And so I want to share one more little story with you. It just popped into my head, so out it comes. Um, I was working with the tribal victim advocate in Oklahoma, and I was a rather new attorney, maybe 6 years in. I had been teaching, and then I went over to actual practice. And I was a go-getter. I'm not so much now, but I was then. And I said to the advocate, we were sitting at the same table, and I was working through my strategy because guess what? Advocates will flag for you safety issues in your practice and delivery. Listen, listen to what they have to say because this tribal advocate was so patient with me. Just listen to me ramble on. And what had happened was her former partner was a drug addict, and he was now sending drug addicts to knock on her door. She lived way out in the country. And I told that advocate, well, I am going to subpoena, I'm going to send out 20 subpoenas. Everybody who came to that door, I'm going to call them into court and I'm going to ask them questions about this. That's a tool in my toolbox. I can do that. The advocate looked at me very quietly after I was through talking, and she said, are you trying to get her killed? And I said, what are you talking about? I can get subpoenas out. She said, what do you think is going to happen to her if she already has drug dealers knocking on her door, banging on her door, yelling bad things at her? She's in a rural place. It'll take law enforcement at least 20, 25 minutes to get there. We need to find another way. And that was my aha moment. I need an advocate beside me because I didn't think about that. That's a tool we have in our toolbox. But the advocate was the one who brought me back and said, her safety is the most important thing. And that will put her in jeopardy. Have you had cases like that, Bonnie, where lawyers just want to do their thing? And
Yes. And it's so important to pull people aside like judges to remind them that, safety is of primary importance. Primary importance. It's, I often tell them it's a life and death situation in most instances, that she knows this is getting worse and that the next thing, it could be her life or the life of her children.
would you agree with this statement, Bonnie? Everything I file and every step I take, I need to discuss with her and the advocate, if I have one, about the safety issues.
Absolutely.
Because we
That's
aren't
best.
taught this in law school. Yeah, I got taught this by advocates. All right, I see in the chat a client who wanted a PO, but no physical harm. If that's an element, no threats. I don't know. I could almost argue, and lawyers out there, intimidation that she feels like puts her in danger, physical danger, or her children. I think I could argue that. I think I could do that, especially if he's blacking out. So I think, and it would depend on those elements, right, in your jurisdiction, what I need to show. I think fear of imminent physical harm, at least in Oklahoma, will get it. Again, we need to check those statutes for those elements. Then I see cultural differences and sensitivities may be factors. Spot on. Story for that. Had my client practice with her, had the advocate, all my safety concerns about what I'm doing. I seem okay with it. I put her on the stand, and she was not a good witness. And it wasn't because she was nervous. Wouldn't say the things I needed her to say, like, my children are the most important thing to me. I'll do anything for my children. If the judge needs me to get this treatment or that treatment, I'll do it. She was just kind of flat on the stand. We won, but when I got her off the stand and I walk out into the hallway, her aunties followed me out and said, do you know why she wouldn't answer your questions? And I said, no, please share it with me so I'll know in the future. And this will vary tribe to tribe. In her customs, if you argued over children who were holy beings, the creator might take them away. And she did not want to do that. I should have asked that question. More experience. This was like right when I was beginning to practice in Indian country. Don't forget, the advocate can also give you that information. Are there any kind of cultural concerns I need to be worried about here? Will anything, and I've had that happen to me more than once. The other time I wasn't present, but I had counseled this person who had to go out state, try to get his children. And the judge in the order remarked he was very stoic He didn't seem to be very caring. But again, from a tribe that had those customs and beliefs. Bonnie, do you have anything to say about that?
No, I will later.
Okay, we've got to know those things. And how are we going to know them if we don't ask our advocates who are actually practicing in the Indian country? Next slide. Okay, tips. Just another way. This is a checklist. And I always found, and I don't know if you have a comment on this, Bonnie, the client's already come to Bonnie. She's already got the story. But if I show the client, and I started doing this early on, here is what I have to prove. Here is what the judge is going to be the most interested in. We can tell the whole story, but let's do these first. I found that that was very helpful to most victims. Some of them are in such a state of trauma, they can't gather and take all of this in, but letting the client, inviting the client to help you put their testimony in, plug into these elements, I found that very helpful. If they're capable of doing that with the trauma that they're under. One of my teachings is disrespectful for long eye contact. Oh yeah, I marched myself right into Indian country, brand new, and I just stared. And I also interrupted. And when I left, I mean, thankfully, her granddaughter was there and said to me, you know why she won't answer you? She stopped talking. You keep interrupting her, and she thinks that must mean what she has to say is not important. Huge issue. Huge issue. Because you see the court movies and everybody's yelling at everybody, and there's the judge is banging the gavel, and just it's a huge issue. So just being mindful of those sorts of things. A victim advocate seems to have much more of a perspective when it comes to their clients. Yes, 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 100 times yes. And that's why, to me, a best practice in these cases really requires you to work with an advocate who can keep all these safety issues in perspective. I was never taught how to do safety planning in law school, so I learned it from the advocates. Next slide. Yes, and blocking her way out can be imminent fear of physical harm. Yes, definitely. Okay, that's it for the protection orders with the elements, the jurisdictional piece, plugging the pieces of the client's story in where they fit with the elements, getting it all organized for the judge. Maybe you're working in a jurisdiction with one of these checklists, just double check it yourself, make sure everything is in there. And I think you're in a good place to go in and get the protection order. And don't be afraid to argue imminent fear of physical harm. Who is it? Lindsay saying blocking her way out. Yeah, if he's standing there and he's got his chest puffed out and he won't let her out, she's probably afraid of what he's going to do to her. So I think you can argue that. I do. Bonnie, before we move into full faith and credit, did you have any comments?
I'm good.
Okay, I just keep bouncing it back to Bonnie because she's the advocate and she's the teacher on all things victim-centered, trauma-informed, and safety. Always, always, always. Okay, that's it. Unless we have more questions on the protection orders, I hope you guys got something out of that. You're going to at least take it under advisement. Think about the checklists we gave you. Think about making your file, running those statutes off so you have it right there. It's so impressive. I was a judge in tribal court in Oklahoma, and I had an outstanding victim advocate, and she would give those lawyers what for in the room. Half the time, the lawyers hadn't even looked at tribal law. And she would say, I have that statute here, Your Honor, and bring it up to me and let me read it. And I would say to the opposing counsel, did you read this? No, I read the state law. Well, you do know that doesn't apply here, right? I mean, maybe you wouldn't be shocked, but it's So important. It's a disrespect to sovereignty to me when you come in there and try to argue another sovereign's law and you didn't even care to check the tribal law. Check it, run it off. Okay. Oh, thank you, Kathleen. Okay, let's move into full faith and credit. Now we've got the elements and the jurisdictional piece. We've got our petition for or application for protection order ready. Do you want that protection order to be enforceable in every jurisdiction, every tribal jurisdiction, every state jurisdiction? And I hope your answer is yes. So, what that means legally is that this full faith and credit we're about to get into, if your protection order is violated in another jurisdiction, that jurisdiction will prosecute it or hold the perpetrator in civil contempt using their own laws. This order is recognized as a valid order by the tribal court, and it doesn't even matter if where the violation took place, that state judge couldn't have put that in their order, but the tribal judge could, according to tribal law. It has to be enforced as it is written. And I see this come up mostly in custody. If the tribal judge awards custody, because in Oklahoma, you can't get custody in a protection order. I was flabbergasted. You have to prove up that the child meets the elements too. Most tribal courts, I'm hoping, knowing the dynamics of domestic violence, the children are the first thing that perp's going to use to control her. So many tribal courts allow the tribal judge to award custody. Do you want that enforced in Oregon? Might have a little trouble up there because full faith and credit, there's a lot of fussing going on, even though we have this federal law and it's very clear. You can ask your advocate. She's going to want to go to Oregon. Is this going to be enforceable up there? By federal law, it is. But what is she going to get into? And the advocates usually get on the phone, call another tribal advocate and say, is the state giving full faith and credit to tribal protection orders? You need all of this information for safety. Practically, it means the victim does not have to worry if she gets a tribal protection order and she goes out across tribal jurisdictional boundaries to the grocery store. That order is enforceable as it is written by the tribal judge. So that's how important this piece is we're getting into now. And now this doesn't go in your petition. It's going to go in the final order. And you're going to be there to make sure it's in the final order. These pieces we're going to talk about. Next slide. Bonnie, you jump in anytime. Okay. Why is this important, Bonnie? Give us some scenarios there.
It's critical. The safety issue, of course, is of primary importance as victims move from one jurisdiction to another. And of course, we know that is the case for many victims, whether it's because, like Kelly said, if they're going to the grocery store or if they have a job outside of their jurisdiction. Also, abusers can stalk victims. So it isn't just because, something happens, they get a protection order, they think they can just follow this person around. Well, if they have the protection order and it's covered by full faith and credit, then they still have a protection order that'll protect them from that stalking, or he can't, keep coming to their place of employment or showing up at the grocery store out of jurisdiction. And then also traveling across jurisdictional boundaries. A lot of victims and abusers travel a lot, like during the summer to powwows, to tribal celebrations, for other reasons. And it's important for that victim to know they're going to be safe as they travel across jurisdictional boundaries. So, I always tell them, look to where you're going, see what their laws are, bring copies, provide copies to the jurisdictions there to law enforcement so that they know you're going to be there. And if he shows up, they know you have a protection order. So when you call law enforcement, they already know who's prohibited from coming close to her, being in the same area. And it also just sends a message to a perpetrator that violations of a protection order outside Indian country will have consequences now. Well, back then too, but more so now, especially non-native. So, it's so important. Before, it's still that way a little bit, but there's a little bit more teeth to the protection orders because of full faith and credit, because a lot of victims were saying, that's not going to help. That's just a piece of paper. That's not going to stop him from assaulting me. But now there's a little bit more protections where it can be a felony if he violates. So, instrumental in recognizing tribal sovereignty by recognizing and enforcing tribal protection orders. If she goes from one tribal jurisdiction to another, then that tribe can exercise their sovereignty by, restricting certain people because victims have this protection order, and their priority is to protect people from being assaulted in their jurisdiction. So it's so important. It's just an important law.
Okay, I see a question. Does the protection order protect custody of the children outside tribal lands? If you have this activating language in the order, the answer is it should. It should. But I would really, I mean, this is what's written in federal law, and it's real life. And I would just urge you to reach out to the tribal advocate who can also, if you know where this person's going or frequenting, visiting relatives, a simple call to a tribal coalition or a tribal victim advocate in that area, they can tell you, oh, yeah, we're not having any difficulties here. They may tell you, oh, if it even comes from anywhere outside the state, no. And so then you start to think, okay, do we need to get a protection order there? Can we get one? Or do we just have the advocate safety plan, right? We're going to get together, we're going to talk about it all. We're going to choose a plan of action. But you will see here in a few minutes custody orders, child support orders. I saw someone with the child support unit is on. All of those orders, if they are a protection order, and we'll go over that definition, and if they have the activating language, theoretically by federal law, they are required to honor that. Next slide. Okay. Here's the federal law, y'all. I don't want to bore you with it. I just bolded what I thought I want to jump out at you. It's basically that your protection order, I'll tell you what that definition, federal definition here is in a minute. And it's broad. It is broad. It says shall be accorded full faith and credit by everybody else, every other jurisdiction, and enforced by the court and law enforcement personnel of the other state outside of Indian country or another tribe as if it were their own order. And again, enforced as it is written. So let's go to the next piece. Hopefully, I won't lose you guys when we're talking about the federal law. I find it invigorating, but I realize other people might not. Okay. A protection order, and again, I'll tell you what that is consistent with full faith and credit. It's going to activate the mandate if the tribal court had jurisdiction over the parties and the subject matter. Where would we find that? Tribal law. And you might even at let's see, tribalprotectionorder.org. If you go there, I think we might have that link at the end of the presentation. It will tell you how to draft the protection order to say subject matter jurisdiction and jurisdiction over the parties. Those are legal terms. We'll go into it a little bit deeper. Okay, so we have subject matter jurisdiction, the tribal court, jurisdiction over the two parties, and reasonable notice and opportunity to be heard has been given to the defendant so that it complies with due process. In other words, you got a notice of the hearing, you didn't show up. Or you got notice of the hearing, you showed up, you had a say, you lost. That's the due process we're talking about here. In the case of your emergency orders, remember the defendant isn't there. It's the client, the advocate usually, and the judge. So you have to follow those timelines that I told you earlier. It might say something like you have to have a hearing within 30 days. You have to give the defendant notice and a hearing within 30 days, but the emergency order is enforceable. Does that make sense to everybody? The permanent protection order hearings will have usually longer dates. And I see Marlon dropped in tribalprotectionorder.org. It's stock full of drafting tips to engage the full faith and credit mandate. That's it. So let's go to the next slide. Probably I repeat it 3 times. Okay, here you go. And this is what the order needs to say. Wouldn't vary too much from the language because it comes from the federal law. And it might say something like this: tribal court has jurisdiction over the parties and matters under tribal code, da 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 da. Reasonable notice and opportunity has been given to the person against whom the order is sought pursuant to tribal code, da 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 da. And it'll have your timelines for the hearings in there and when they get notice. And then it's got some language in here for ex parte orders. You're going to have to follow the timelines in that unless you can't get service. Usually the timelines will say unless there's no service, service is continuing, or the judge finds good cause to keep the ex parte or emergency order in place. And you're going to say, we did that. And know that this used to happen a lot, Bonnie. I don't see it happening so much anymore. It's when she shows up to get his protection or her protection order. He says, I want one too. She hit me too, and I need a protection order. That protection order, that counter protection order, is not entitled to full faith and credit unless it has the language in it. And the judge must make specific findings on why each party is entitled to a protection order. In other words, I'm going to hear evidence and I'm going to say, I feel that counter petition of protection orders is warranted here because, and then I'm going to have to give a reason. And I hardly see that happening anymore, Bonnie. Do you?
I see it happening. I hear stories about it as I travel that abusers are getting protection orders.
Okay. Well, we want to make sure that you remember that provision is there if that is happening. They also have to have a filing. They can't just say I want one. They have to fill out an application, write the story, meet the elements, do all of those things. Okay, next slide.
Kelly,
Yeah.
we had a question about reactive abuse.
Reactive abuse, is that like self-defense, something like that? Can you tell me more? Is it Sienna?
Yeah.
Yeah. Bonnie, do you know what reactive? There are so many different terms. I'm going to say she's trying to defend herself, or he hits her and then she hits him back because she wants to get away. Yes, yes. Okay, yes. Yes, I think you can bring that up. I absolutely think you should bring that up and persuasively for the judge to know exactly why she was doing what she did, if it's the case of a counter or cross petition, for sure. Yeah. Okay. Any other questions?
I would use another term than reactive, though.
Okay.
And then they'll start to look at predominant or primary aggressor.
Okay.
So reactive, I think, just minimizes it's the same. It'll be put in the same context when it's not. It's actually self-defense.
Yes. I would agree with that, but I know other jurisdictions might have other terms. So, okay. Now what we're gonna dive in a little deeper to full faith and credit. Wait, okay, there's one more question from Kathleen. If tribal code does not allow mutual PPOs, does VAWA trump it? I'm not sure I understand that question. Are you asking if can she get one if he already has one? Is that the question maybe? And if they're doing it at different times, that's not a mutual PPO. Mutual is where they're both in the courtroom on the same day with the same filings. So, Kathleen, if you want to explain that a little bit, I'll go on through the definition, federal definition, protection order, jurisdiction over the parties and the subject matter, the due process piece. So let's go on down. Okay. There's another question. You can go ahead and switch a slide, Marlon. If full faith and credit is unclear, oh, I don't want it to be unclear. I want the activation language to be in there. Is there an interstate doctrine to use state to state or reservation to reservation? Good question. Some states have cooperative agreements with tribes about we'll enforce your order if you enforce our orders. I mean, do what you need to do. It's up to the tribe. But myself, I see that affront to sovereignty because you don't need it. Tribes are sovereigns, and now there's this federal law that says if the PO has this language in it, it has to be enforced across jurisdictions. But some states and tribes do have that sort of, if you do ours, we'll do yours kind of agreement. Okay. If a code says no mutual restraining order, then client wants a PPO, does she argue VAWA? I don't think VAWA gives a person a right to get a. Here's the thing. If you're talking about a tribe's civil jurisdiction to issue, you saw Quapaw. They didn't go that broadly. They said, nope, only these cases we're going to hear. So I don't think VAWA is going to trump tribal law there. I don't. But again, if he gets one against her, and then she shows up and she has her own filing at a different time, I think she should, if she can meet the elements in the jurisdiction, I think she should be able to get one. I mean, that's what I'd be thinking as a judge. It doesn't bar me from doing it. I'm just not going to call it a cross or counter because he got one and it's over. And now she needs one and we'll treat her separately. That's what I'm thinking there. Okay, let's take a look at what Congress wanted to fit within the definition of a protection order for full faith and credit purposes. I'm not going to read it to you. It's everything. It doesn't matter what it's called. It doesn't matter if it was issued as a part of a divorce. If it has as its purpose to protect, restrain, limit contact, that fits within this definition of a protection order. It could even be a criminal no contact order if he's been charged with the crime and the prosecutor gets a no contact order. If it has this activation language in it, it's enforceable everywhere. If not, it's still a protection order, but it's maybe limited to tribal boundaries. Within tribal boundaries. It says as long, here's the requirement, any civil or criminal order was issued in response to a complaint, petition, or motion filed by or on behalf of a person seeking protection. That's anything else is going to fit within this definition. Let's go to the next slide because it has another piece to it. And I saw someone works for child support. It includes any support, child custody, visitation provision orders as a part of that big definition of a protection order. So you can kind of take a look at that. Again, it doesn't matter if it's called an injunction, a no contact order. It doesn't matter if it's in a divorce decree. If they're ordered for purposes of protection to do certain things. That's what a protection order is. You still need the activation language to kick in the full faith and credit, though. And let me know if that's not clear, and I'll go over it further. But otherwise, we'll skip on down. Okay. On subject matter jurisdiction, in your final orders in tribal court, check the order to see if it's cites to tribal law, because there are still state court judges who don't even know there are tribal courts, right? And when you put the citation to tribal law in there, oftentimes they can get online and look it up and say, well, looks to me like they had jurisdiction there. Okay. So you might find it in your tribal constitution. You might find it in tribal statutes, and it will say something like you saw Quapaw say. This tribal court can issue and enforce protection orders if you meet these jurisdictional factors. Okay? So that's subject matter jurisdiction. And what it means is there's a statute or a constitutional provision that says this court can hear civil cases and protection, or if this is a civil protection order, that's enough. It fits right in there. Okay. But many tribal codes nowadays have a domestic violence code, and they're going to set it out for you. Okay. Next slide. This is that federal law I told you earlier that says tribal courts have the authority, full civil authority. That's protection orders, that's civil contempt, that's full civil jurisdiction to issue and enforce civil enforcement protection orders involving any person. Couple of qualifiers here. In matters arising in Indian country, that means think broadly. Was there a threatening phone call she answered while she was in Indian country? Anything that happened in Indian country. And it even adds or otherwise within the authority of the tribe. And the folks who drafted this, we've had long conversations about what that otherwise within the authority of the tribe means. And I apologize in advance, I'm at to get legal with you here, what we think it means, but it's an untested question of law. If anything happened inside of Indian country, the tribe has it, number one, by federal law. It's a reaffirmation of tribal authority. But the second piece is you might see something like Quapaw, who really has decided for their purposes, they've restricted it. And you have to be a member, or you have to work in the tribe, or you have to do this or that for the court to be able to issue a protection order. So go look at tribal law, run it off, put it in your file. Next slide. Okay, I'm going to get legal. I told you I would. What we think, these are the TA providers for the Intertribal Working Group anyway, what we think that phrase means is some tribal courts will allow their citizens to come back into Indian country. They run from wherever they were. They come back to the tribe. They need to get a protection order. And by tribal law, they can get it. I think that the tribe will have to meet the requirements of this Montana test. They don't have to meet this if it happened in Indian country. If it didn't, and it's a non-Indian perpetrator, the tribe will have to meet this Montana test. And I'm going to tell you what it is, and I gave you the site. So let's go to the next piece. Okay, here's the test. The parties entered, this is for non-Indians. The parties entered into a consensual relationship with the tribe or its members. They may have been having a relationship, but the latest Supreme Court cases, I'm not sure that we could meet that, even though it seems like just the black and white letter we could. Or the conduct threatens or has some direct effect on the political integrity, the economic security, or the health or the welfare of tribes. Have you seen the statistics lately about domestic violence against Indian women? Congress even made the findings that led up to VAWA 2022. And I would definitely argue that, but you're going to have to argue one of them. If it happened outside of Indian country and you have a non-Indian coming into tribal court, you're pulling them into tribal court. So it gets a little more complex. It gets a little more complex if it's outside of Indian country. But like I said, Bonnie, would you agree that domestic violence cases, there are ongoing acts of domestic violence. And if she answers a phone call, or if he sends somebody over to tell her something threatening, that I would argue the tribe would have that. That is happening in Indian country.
Absolutely.
Okay, so I don't want you to be threatened by that, but I did want to point it out to you. If it happens outside of Indian country, you might need to do a little more legal wrangling to show jurisdiction if you can't show anything happened in Indian country. Okay. Yeah, I just said that, so we can go to the next slide. Sorry. Okay. All right, the checklist. Who? List any requirements in the statute regarding who might file a protection order. Contacts the petitioner and defendant have to the tribe. I always ask this question. Did you know you were marrying a tribal member? Do you have children in common? Do you accept any tribal benefits? You see where I'm going with it? I'm trying to create that nexus with Indian country. Identify what the statute requires to serve a protection order. Oftentimes it's going to be tribal law enforcement. If you have to go outside of Indian country, tribal law enforcement will know how to get that done, how they do that typically. Sometimes there are agreements between the states. And then if it's an emergency PO, what does the statute require to hear with respect to hearing dates if it's an emergency protection order? Also the permanent protection order, I would add that to the list. Okay, next slide. Okay. Okay, I wanted to add this to you. Advocates, you might think this is important too. I know the lawyers will. Generally, unless prohibited by federal law or tribal law, a person, that's all I'm going to say, who is a non-member of the tribe residing outside the tribe's territorial jurisdiction generally submits to the jurisdiction of the tribal court by doing any of these things. And so I would tell you, I would always go through my little laundry list because I'm going to find jurisdiction over this person. If they commit a tortious act in Indian country, if they have any interest in property, real or personal in Indian country, I'll just leave this list up there. You'll have it. You can kind of go down through this checklist if you're trying to work with a non-member, maybe non-Indian who is outside of Indian country. Can we go to the next slide? Okay. If they're living in a marital relationship subject to the tribe's jurisdiction, they got married in Indian country, even if they left, I think you can get them. Is the parent, custodian, or other person with a legal interest in a child subject to jurisdiction? You might be able to get quite a few through that. Or accepting a privilege from the tribe, or entering a consensual relationship with a member. So that list is just another checklist if you've got a stickier case where you maybe have the non-Indian outside of Indian country and you're trying to pull them in. It could be an Indian too, I suppose, but many tribes will have jurisdictional statements about Indians. Okay, next slide. Okay. Due process, that's where we are now. We did subject matter, jurisdiction over the parties. That was just the one we just did. If the defendant shows up in tribal court, you got him. Unless he shows up and contests jurisdiction, you got him. Identify whether the defendant's been served with a copy of the petition and get this in the tribal record. It has to be in the tribal court's file, that return of service. Identify whether the court date has been scheduled according to the timelines in the statute. If the defendant appears and doesn't contest personal jurisdiction, like I said, you got him. Excuse me. Was the defendant provided an opportunity to tell the defendant's side of the story? Oh, I had an attorney call me frantically, an Oklahoma attorney saying, oh my gosh, the judge came in, read the application for the protection order. The defendant stood up to say something, told the defendant to sit down and shut up. He was going to grant the protection order, and he didn't want to hear a word out of the defendant. how are you going to show they had an opportunity to be heard? So quickly, I told the attorney to tell judge that in order to get full faith and credit, we have to show the defendants had an opportunity to be heard. And so the judge backed up and did it correctly. I think it might have been traumatic for the client because she thought she had won right off the bat and didn't have to hear any confrontations or stories, but we have to have that piece to activate full faith and credit. Next slide. Oh, here we have Jerry Cook saying the Eighth Circuit just recently ruled that marrying a tribal member isn't sufficient for the tribal court to exercise jurisdiction, even if the spouse accepted support from the tribe. Oh, that's a hard case there. I would probably need to know all the facts there because it seems to fly in the face of what we know about jurisdiction, but it's an Eighth Circuit case. So I don't know what the case was about. I'm going to read it though. Okay, remedies. When we're talking about remedies, I think the number one thing, because I'm running a little short on time, I want to say, look at the list of remedies in the statute. Know that if you're going to ask for spousal support, know that if you're going to ask for personal property, you have to put on testimony to show that. I've seen that many times in tribal court. I want to give it, but I didn't hear any testimony about it. So don't forget that important piece. And remember also, and Bonnie, you might want to jump in here, the remedies need to be tailored to what the client is telling you she needs. She is driving what remedies you're asking for. Do you agree with that, Bonnie?
Absolutely. And to have that discussion with her early on.
Early on, when you're first meeting, you're going to go through the whole thing, the elements, the jurisdiction. What is it that you need out of this list of remedies? And is there anything not on this list that you need? Okay. Oh, thank you, Kathleen. Okay, next slide. Bonnie, I'm going to hurry through some of these. Okay, Bonnie, can you do that
Safety,
one?
safety planning, always ongoing, always at every juncture, every meeting, every opportunity to find out how safe she's feeling. Does this address her concerns for her safety, safety of her children? And even in the location where you are, in the courtroom where you are, any little thing is so critically important. And then to make people aware within the courts about the importance of safety and some of the things that perpetrators, abusers do to intimidate victims is important for people to keep a watchful eye on, because that also may shut that victim right down. They may not want to talk when they need to be able to get the kind of protection and what they're requesting as part of this protection order. Um, respondents may be transient. Like I said, people move around, especially during warmer months when travel starts to happen and powwows start up. So I've helped a lot of victims with taking protection orders, sending them on ahead to where they're going, like for a specific reservation where they're going to send their protection order to the law enforcement to look into what the requirements are for protection orders there, and if they have full faith and credit. I even tell them, take copies of the laws that you're working from so that you can address any kind of concerns or questions. Send pictures of them, descriptions of this person, if they have a car, all of these things, so that law enforcement are aware of what's going on ahead of time, so that if that person does show up and starts to be intimidating or whatever, that they can call the law enforcement and they'll know right away what they're talking about. Um, and then also when you get into court, I've heard so many abusers deny that this is happening. So, and that really puts victims on edge and they feel intimidated. They start to get scared because they recognize all of the signs that this person's escalating. They're angry. She's lying. She always lies. All of that can start to happen in court. And again, that's another way that a victim just shuts down because they're so afraid of what's going to happen, what's coming.
And I just want to say, lawyers, read all of them, but you should be asking your advocate about the client's trauma level and getting them ready to hear these things because it's going to be the first thing out. I promise you. Next slide. Reach out also to your advocates. And if you don't know, we've already said this, if you don't know if the tribal protection order has a chance of not being enforced and you did everything right, you've got your full faith and credit activation language in there, here's who you reach out to, your tribal coalitions. Call the advocate. I hope you're working with the advocate anyway, and the victim will also tell you. Next slide. Okay, we're down to the questions. If you have any, put them up there. If not, again, I started with this, I'm going to end with it. Attorneys work with advocates. It is a best practice, even if you're worried about confidentiality, which is coming up on the next slide, Marlene. A simple phone call to say, brief me on safety concerns, and let that advocate just talk to you. The next webinar, which will be next Wednesday, is on privacy, confidentiality, and privilege issues when attorneys and advocates work together. We'll have a guest speaker, Shelley Miller from the Native Alliance Against Violence, which is Oklahoma's tribal coalition. We're going to go through that and some of the workarounds she's had to do, because that is one project that pairs attorneys with advocates. They are required to work together. Thank you, Bonnie, for working with me today, and Marlon and Suzanne, and thank you all for joining us. And Marlon, what else do we have? Resources at the end here? Yes, lots of TLPI resources. You guys will get this. It's a part of the PowerPoint. Tons of resources at TLPI. Most all of them are free for download. And if you could please complete the webinar evaluation, you can do your handy dandy phone thing. And if you're slow at it, you can use the link, which I am. And thank you again, everybody. Please keep doing your work.